Good morning, everyone. This is Steve Hoffaker. Welcome to our last webinar program of 2023. 2024 has a whole another set of programs. I think we have 10 or so scheduled for next year. Check the schedule. You can sign up for them individually. You can blanket enroll if you like, and we'll have a lot of really good speakers for you, some that you haven't heard of before on topics of interest to you in your CAPS and renovation programs. Today we have a fantastic program. Meredith, if you've been with us in the past, I did a program once before, and in talking to her before she gets started today, I think she's got a lot more to share with, I know today, but I think in the future, we'll have her back to do some other programs. Really good information on a topic that is largely misunderstood for our aging in place industry. So we came up with this program today. When do HIPAA rules apply? And that's what Meredith is going to talk about. And Meredith has, well, I'll let her tell you about her own credentials, and I'll jump back in here at the end. So Meredith, go ahead, please.
Thank you, sir. Thank you for having me. And as Steve mentioned, my name is Meredith Mull. I'm actually a CAPS certified occupational therapist, and I've been in healthcare, mostly in operations, business development, and strategic consulting for about 25 years, a little longer than that. And I currently serve as the chief of staff for a company called Alapex. We are a care coordination company, so we work with physician practices to provide all of the at-home monitoring and chronic care management of their patients. So I have a master's in OT. I also have a master's from the School of Public Health at Johns Hopkins in population health management, and currently working with Steve and the CAPS program, as I am also a certified HIPAA administrator. So hopefully you all will find some value in what we're going to talk about today. So let me make sure everybody can see my slides advancing. Just give me a thumbs up. Okay, perfect. All right. So for our agenda today, let me just see if I can move these. There we go. All right. We're going to kind of go over what the purpose and history of HIPAA law is and who governs the authority of it. We're going to give an overview of the actual information that HIPAA protects and what the law expects from those who are required to follow it. And I think it's really going to be important to understand these things in order to know how to apply it to your specific businesses. And then lastly, we're going to walk through some very specific scenarios to see if you can guess where HIPAA does or doesn't apply. And then we're going to touch on the topic of privacy and confidentiality. And so we're going to end up giving some brief recommendations for therapists who actually consult with GCs, and then for CAPS GCs themselves, just some things to consider. And then we're going to open up the floor for actual questions. So I do want to start out by mentioning the information that we go over today should not be seen or taken as legal advice. While I am certified in HIPAA and I'm educating you on how to make decisions for your business, I'm not an attorney. So it's important to actually point this out. But all of the information that's provided during this presentation and the applicability of HIPAA law to your individual business should be run through your legal counsel and or your company compliance officer. Okay. So I think it's really important first to understand what HIPAA is and why the HIPAA law exists. So HIPAA actually stands for the Health Information Portability and Accountability Act. And it's a federal law that was created for a variety of purposes, but mainly to protect sensitive medical information of individuals like you and I. So as a consumer of healthcare services, which we all are, it's important to also know what your rights are. And so this is why when you go to the doctor's office, for example, you sign paperwork that shows you that you received their privacy practices and it explains what your doctor can do with your information. So that consent gives them different allowances for using your information to treat you, for payment of your services, and for their own internal healthcare operations. And then for providers, it's important to understand what you're required to do by law. And so providers are going to be interchanged in this presentation with clinician or doctor or practitioner. But when I say any of these, I'm referring to anyone that's practicing medicine or offering healthcare services. Okay. So there are going to be some things that providers need your permission for, and some for which they do not. And so that's a really important distinction. So some examples that are going to require your permission and therefore protect your information are for things like using your information, let's say, to do a targeting marketing campaign, or possibly for like things like clinical research. And then secondly, HIPAA is purposed to allow a person to have greater control over their health information, like what can be shared with other people. Um, and the law states that you, as the consumer of healthcare services, own the information about you. And therefore, you should be able to access it whenever you want, with some exceptions. And you're going to hear me say with some exceptions a lot. There are a lot of exceptions. Okay. You also have the right to know who has accessed your information with various exceptions. And these rights also give you the ability to maybe request corrections of your medical record or ask for copies. You can request restrictions on the release of your information to others. It also gives you the right to know when your information was illegally shared or accessed. And this is something that's known as breach. And we're going to go over what that means in a little bit more detail. But essentially, it allows you to know when your information was accessed or shared outside the law or outside your permission that ties to the law. And so I want you to note that there are a host of exceptions to these, but I just want to relay the general premises to make you understand that not all disclosures of your medical information need your permission, and not all of it is tracked. So if the information is used to treat you, if it is used to make payments for your healthcare services to, say, like an insurance company, or it's used in the day-to-day operations of a healthcare provider for their business purposes or their quality assurance purposes, it's allowable without your permission. And the reasoning behind this is that the rule can't be so stringent that it interferes with good healthcare service delivery, and it can interfere with the operation of the healthcare business itself. And then lastly, the purpose of HIPAA is to help healthcare providers better care plan for their patients. And that's so they can have information more readily available to them. So this is why doctors don't need your permission to share your health information with an emergency room physician, for example, if it's going to be used to treat you and save your life. HIPAA also creates very specific rules around electronic documentation of health records. And that's to ensure that it's protected, but it's also available and easier to share. And what that really means is that while there are stringent rules to protect all of the information about you, there's even more stringent rules that when that information sits inside of a computer or an electronic device. So HIPAA has some really interesting history, and it actually took quite some time to evolve into what we know today. I think Rebecca, one of the attendees, and I were just talking about, she recalls when HIPAA went into federal law. And so we're not going to go into depth on it, but I think since it affects all of us who use doctors, hospitals, therapists, et cetera, it's worth pointing out its evolution. And so HIPAA was signed into federal law in August of 1966. So interestingly enough, before I graduated high school, there was no protection by law around my individual health records and the information that my doctors kept on me as a child. So a government entity known as the Department of Health and Human Services, they created the first HIPAA rules in 96. And then in 2003, those original rules were expanded to what we know today as the privacy rule. And that rule really defined what we call PHI, or protected health information, which we're going to go over later because it's a very important distinction for you to understand. And it really defined everyone who had applied to and when they had to comply with the rule. And then the HIPAA security rule came onto the scene 2 years after that original legislation in 2005. And it really provided the rules around electronic health records and billing for things electronically, because by then we were moving more and more towards an electronic-based society. And then in 2006, what was known as the enforcement rule came out. And that's because the government felt like there were a lot of healthcare entities and organizations that were really dragging their feet with compliance with those rules. And so they instituted fines and penalties for non-compliance. And then in 2009 is really kind of the biggest update in HIPAA history. the HITECH Act was created. That's the Health Information Technology for Economic and Clinical Health Act. And this primary goal of this legislation was for compelling healthcare providers to implement the use of electronic health records. So what we kind of know of today is we go into the doctor, they're not really documenting too much on paper. They're putting everything into a computer when they're talking to you. And so that rule also expanded upon the enforcement laws with the breach notification rule becoming effective. And this is the rule that required that those that have to follow the law have to notify you, the consumer, the patient, when they mess up. And they instituted fines on those entities. And then lastly, the last big law or change in HIPAA came with the final omnibus rule of 2013. And that just essentially filled some of the gaps in some of the existing regulations. So for example, it specified the encryption standards that need to be applied in order to render electronic data. And for those who are unfamiliar with the word encryption, it basically is software that takes all of your data in electronic form and it scrambles it all up before it sends it over the World Wide Web, so that if it was intercepted by someone who shouldn't have it, they wouldn't be able to read it until it's decrypted on the receiving end by someone who also has that technology to do so. So now that we know the purpose and how it really came about, it's important to really know who's actually in charge of HIPAA and who's responsible for enforcing those laws and those rules. And like we said, HIPAA is a federal law, and the government assigned their OCR, or their Office of Civil Rights, to enforce and basically police the rules. Okay. And their job is to really audit those who are required to follow the law. They want to make sure you're following all the rules. They have to investigate any complaints or breaches that come from patients or individuals, and they have to penalize any offenders accordingly with the fines and possibly even jail time for breaching information. Okay. So it's interesting to note that 60% of the time where the OCR has to be involved in some sort of investigation, breaches or mistakes are occurring electronically, as we live in a world full of hackers and online criminals who aim to really steal the data that's found online. So a favorite place for these criminals to attack are healthcare organizations who have sensitive data. And they have this in electronic form. So it's a pretty easy target for them. And what they do is they hack the system, and then they essentially hold your information for ransom until the healthcare provider pays them for it. And this is what's known as ransomware. And this is an example of what's considered a breach of the law. Okay. So the government expects you to protect the data that you hold in your electronic system from online criminals. Okay. Another key point that you want to pay attention to is that even though HIPAA is a federal law under the watchful eye of the government, there are some states that have more stringent laws than the federal ones. So when that happens, the entity has to default to the state laws and rules. So this is another reason why you would want to always consult an attorney about your proper business setup as it relates to HIPAA in relation to CAPS. So when you talk about breach and what the OCR is supposed to oversee, we really need to understand the actual information that the government seeks to protect when it comes to your health data. Okay, so HIPAA is essentially concerned with what is known as protected health information, or PHI. And PHI is actually a subset of what we know as individually identifiable health information, or IIHI. And so I'm going to break this down for you a little bit because there's a definite distinction between the two. Okay. Individually identifiable health information is information that describes certain demographics about you, like your age or your gender or your address, that's gathered in the course of receiving some sort of medical services. Okay. So if you think about when you typically go into your doctor's office and you sign in, they hand you a clipboard and you're filling out information about yourself. That's IIHI. You're in a doctor's office and you're filling out your personal information. But what HIPAA protects is a subset of that information known as protected health information. And this really is a marriage of the information that identifies you, plus the addition of medical services that you received that's transmitted or maintained in any form. So transmitted is key for you to remember, because this is going to come up later. But the important things to know about PHI is that it includes your health data that was provided by you, that was created by your healthcare provider. So let's say they gave you a diagnosis, or it was received from one provider to another. So maybe your specialist to your primary. And that's transmitted or maintained by someone. Those are the folks that are required to follow HIPAA rules. So as an example, when you're filling out that demographic information on paper, you're in the waiting room, that's IIHI. Well, once you see the doctor and he marries that information with your blood pressure readings and the rest of your physical, maybe some records from your specialist, he gives you a diagnosis and they place that in their computer. This is your PHI. Okay. And so, interestingly enough, it remains protected by HIPAA for 50 years after you die. Okay. So, there is some information above just your PHI that has even higher levels of protection. And that's what we call psychotherapy notes. And any use of your psychotherapy notes for any reason requires your authorization with a few exceptions. So at the same time, it affords the doctor protections in using that information or sharing that information with you or others. So you start out with IIHI, HIPAA is concerned with PHI, and then there's an even higher level of protection with psychotherapy. So what does HIPAA expect when it comes to protecting that PHI that we just talked about? Well, it wants to ensure that when you use or disclose someone's health information, it's at the very minimum necessary to get the job done. So essentially, the government expects that there should be reasonable effort given to ensure that only what is needed is shared and only with the people who have the rights to see it. And they expect you to do this all the time. HIPAA also expects that you won't breach or disobey the law. And a breach of the law occurs when a provider or a person who must follow HIPAA uses or discloses someone's health information improperly, or someone who's not supposed to use or access it does. So, for example, the ransomware incident we just talked about a few slides ago, where someone hacks into the electronic medical record system of an organization and locks down all the data, and you no longer have the ability to access it until you pay for it. And so when these rules were created, it was meant that you have to follow them only if you qualify. But if you do qualify and you don't follow the rules, it's a breach of the rule. And there, of course, because HIPAA is so gray, there's a host of exceptions to breach that are unintentional or maybe possibly inadvertent, but they're very specific scenarios. And breaches are very serious, and they can come with fines, and they can even come with jail time. And fines and penalties often deal, and how they kind of determine those, they deal with the type of information that was breached and how many people were affected by it, or maybe even how many times you've done it, right? So the Office of Civil Rights has instituted an online wall of shame, and this is what you'll see here on the screen, where if the breach affects like over 500 individuals, you have to self-report it on this site, and it's open to be viewed by the public. These incidents often end up in the media, and they typically cause reputational damage for the provider. So essentially, you don't want to be on this wall. HIPAA also expects providers bound by the law to follow each and every one of their privacy rules. And trust me when I tell you, there are a lot. So some of these examples are that they would expect you to train all your employees on the law and develop employer-specific policies and procedures on using PHI. They're going to expect that you punish or impose sanctions on your employees who violate those policies when you need to. You obviously have to audit and monitor that. That you would only use or disclose a person's information as the law allows. And outside of that, you would track all of those special circumstances in the event a patient wants to know how you use their information outside of treatment, payment, or healthcare operations. You have to have patients acknowledge your privacy practices and have them posted in your office or your clinic. And you have to provide their authorization for sharing the data, as they technically, as the patient, now own it. You also have to appoint in writing a privacy officer who's responsible for managing, overseeing, auditing, and monitoring all of that stuff. HIPAA also expects that you follow their security rules that came with the HITECH Act. And a lot of this stuff is extremely technical, so I'm just going to try and summarize it the best I can. But they expect you to implement or have a plan to implement all of the security and technology safeguards of a person's PHI. And even if you can't meet the rule exactly how it's written, they want you to try to meet it as best and as affordably as you can, and then demonstrate you tried or you're trying to comply with it. It's a lot of work. The rule expects that you reasonably protect all the information that's in electronic form from being stolen or corrupted or maybe possibly used improperly or just from being destroyed by like a fire, for example. So some of the examples of those safeguards would be like having software firewalls, maybe antivirus software. There's certain access controls like having passwords and multi-factor authentication, which we're probably all familiar with either from our jobs or even personal sites that we shop on and have accounts, right? They also require encryption and decryption solutions, which we kind of talked about, that scrambling piece, and even kind of how do you plan to back up your files? And they want to ensure that your workforce members know how to conduct themselves electronically when it comes to sharing and accessing people's health information. And then obviously you provide sanctions if they're violated. So when we talk about electronic healthcare transactions, we are talking about things like submitting healthcare claims to insurance over the web. That would be something like emailing information about a patient or using or accessing someone's electronic medical record inside of a system. This could even be using an app on a mobile device or using online patient portals. So any of those aspects that are electronic where someone's PHI is sitting. So I think one of the most important things that you're going to learn today as it relates to your CAPS designation is who has to follow HIPAA federal law and when it may or may not apply to your business practices. And so if you are not bound by the HIPAA law, and please hear me when I say HIPAA does not apply to you. And one of the key takeaways from today is that if you present yourself to clients as following HIPAA, then you must follow everything HIPAA requires in all of the things that we just discussed. And that's just a high level overview of it. And if you don't have to, by law, follow the HIPAA rules, you should not present yourself or your business as doing so. Essentially, don't toss it around as a buzzword or write it on business collaterals because it sounds cool or professional, as it could really get you in trouble. Okay? HIPAA only applies to entities, organizations, or healthcare providers who fit one of two descriptions. And this is going to be very important, okay? One of them is what is known as a covered entity. And this is technically a health plan, a healthcare clearinghouse, or a healthcare provider who transmits any health information in electronic form in connection with a healthcare transaction. So the key here is transmits any health information in electronic form in connection with a healthcare transaction, okay? A healthcare transaction is an electronic exchange of information between two parties to carry out financial or administrative activities related to healthcare. And those are things that are bulleted on this slide, okay? These are things like coordinating patient benefits, billing for healthcare services, obtaining doctor's orders or prescriptions online. If you are not doing this, you do not meet the definition of a covered entity, and therefore HIPAA does not apply to you in the course of your daily business activities, okay? If you are unsure if you're a covered entity or you fit the definition of a covered entity in your business practices, you should consult your business or healthcare attorney, okay? Now, I've provided some links here to some online tools and information which can help you determine your status. There's a decision tool link that's very user-friendly and a link to the government website that really kind of goes into detail on transactions that lump you into the covered entity category. But the point of this is if you are not, by definition, a covered entity, don't market yourself as one. But if you are, you have to operate within the confines of all the laws and rules when you're dealing with clients or patients, okay? The other category of entities, organizations, persons, or providers that are required to follow HIPAA law are those that are considered business associates of covered entities, okay? A business associate is a really broad term, but it refers to any person or entity that either works with PHI on a covered entity's behalf or one that received PHI from a covered entity in the course of transacting business, or that you handle that data transmission involving PHI between that covered entity and somebody else. So some examples of roles that would fit the definition of a business associate would be consultants who need to access PHI to audit documentation of hospitals for quality assurance. The hospital is the covered entity. The consultant would by nature be a business associate. Or a medical transcriptionist who takes PHI and transcribes it for a doctor. The doctor fits the definition of a covered entity. Therefore, the medical transcriptionist fits the definition of a business associate. If you are an accounting firm who accesses PHI out of a system to do the books for a skilled nursing facility, a skilled nursing facility meets the definition of a covered entity. So you as an accounting firm, by nature of what you're doing, meet the definition of a business associate, okay? If you are an attorney and you function as outside legal counsel of a healthcare company who uses and stores PHI to help their client with a ransomware case, the healthcare company is by definition a covered entity. You as outside legal counsel would by definition be a business associate because of the nature of what you're doing. Or even if you were like an answering service that was taking after hours calls from patients who need refills of their medications, right? The doctor's office would be the covered entity, and you as the answering service would be by definition a business associate. So notice the one thing that all of those examples had in common. It was that they had to access, use, or store the definition of protected health information in order to do a job on behalf of their covered entity client. And that by nature makes them a HIPAA business associate.
Trying to say, clearly this is not it, but you know what? I don't care, because you're my slave, can't you see?
Is there a question?
Because you're bad at dancing, you don't care.
I can dance.
No, you're really bad, I'm really bad, but we dance our own way.
Do you
We're good. We're good.
we're good? Okay. So can you be all of these companies and HIPAA not apply? Sure. I mean, the devil is really in the details of the business transaction that you're conducting. But this is just to give you kind of a general overview, because this is gray. And this is why I will encourage you time and time again during this presentation to seek legal counsel about your particular business. But now what typically happens if you meet the definition of a business associate is you will enter into a very specific agreement, what's known as a business associate agreement, with that covered entity client to follow all the same federal rules that they follow. So again, the keys for a business associate are you are doing something on behalf of your covered entity client, and you have to use PHI to do your job for it to qualify. So knowing what HIPAA is and what it requires and who needs to follow it is really only half the battle. Now what we're going to do is we're going to take some time to go over some very specific scenarios about where HIPAA applies and who it applies to. And again, you're going to hear me mention that this is such a gray area. This is why I would encourage you, if you ever have any questions, to seek counsel about your job and have them review the job duties that you're doing and ensure that you're set to follow up the right rules. And that's really the goal of this presentation, is to educate you on the liability of misrepresenting yourself and get you to think about possibly passing on instances or business opportunities to avoid being tied to federal law if you don't have to be, because there's a lot of work, a lot of oversight, a lot of cost and liability in doing so. What you don't want to do is tie yourself to following very specific federal laws when they are not required, right? Because this will increase your liability as both a licensed individual and as a business. So mentioning HIPAA or following HIPAA, advertising it, requiring a HIPAA consent form, anything labeled HIPAA that you actually have someone else sign ties you into needing to follow all the laws because you are representing yourself as such to the public, okay? So now we're going to go over those scenarios of where it applies, and I want you to pay attention to the details and the little nuances in each scenario as they can change the answer. And we're going to give you about 30 seconds or so on each question, and then we'll just kind of review the answer so you can just write them down. So in scenario one, you have a news media reporter. She's asking a football player if they are vaccinated during a live TV news conference. Is this a HIPAA violation? If you answered no, then you are correct. It is not. While it may be a private matter, depending on who you ask, the news media does not meet the definition of a covered entity, and they do not meet the definition of a business associate. So to interview someone about their own personal information and that person deciding to disclose it or not is not a HIPAA violation. Reporters are generally not required to follow HIPAA federal laws. Scenario 2, you are sitting at home and your physician's practice front office staff calls you to verify your insurance information for your upcoming visit as a new patient. Does this fall under HIPAA PHI? Oh, and it says yes. Okay, gave you the answer already. It does. The physician is calling about your insurance, which means he or she plans to submit a claim to that carrier for your doctor's visit. Okay, and so this will contain your IIHI, your individually identifiable health information, and PHI. Since almost every insurance out there requires electronic submission of claims, this would make your doctor a HIPAA covered entity. Okay. So scenario 3, you're a CAPS general contractor and you were provided information on a client's health condition from the client's occupational therapist in order to design some adaptations to the client's stairs during a remodel from a progressive condition, okay? The therapist is not practicing under their license and they're only working in the capacity of a private pay consultant to the general contractor and to the client. So in this scenario, does the general contractor have to follow HIPAA or have the client sign a HIPAA form?
No.
You answered no, you are correct. Okay. So for one, the GC does not meet the definition of a covered entity. Okay. And if the therapist is a consultant that's being paid privately and is not a covered entity themselves, then the general contractor doesn't meet the definition of a business associate. Okay. So could that general contractor get their work done on those stairs without needing to know personal, intimate details of someone's health condition? Most likely, absolutely, right? And remember, a client has the right to disclose whatever they want about themselves to you as a GC. This does not make it protected under HIPAA. So in scenario 4, you are visiting your dad who's in the hospital. And when you're on the elevator, you overhear a nurse discussing a patient's care in detail to their colleague. And so as you continue to listen, you're able to glean enough information to ascertain that, wow, they're talking about my dad's hospital roommate. Would this be considered a HIPAA violation? If you answered yes, you were correct. So hospitals meet the definition of a covered entity, and therefore all of their workers have to follow the privacy and security laws. So conversations that happen about patients and their care have to be conducted in more private areas than an elevator where others can hear, which I think is pretty common sense. And if no names were used and the person being discussed could not even remotely be identified, it's likely not a violation of HIPAA law, but it would certainly and most likely violate hospital confidentiality policies. So in scenario 5, you're an occupational therapist who works as an employee for an outpatient private practice, and you are licensed in the state to treat patients, okay? And you often refer your clinic patients to a CAPS general contractor when you recognize a need from just working with one of those patients, okay? And through this relationship with the general contractor, you're providing that GC with patient information from your electronic medical record system. You always get the patient's consent first. Does this fall under HIPAA and is it allowed? If you answered yes, it is HIPAA, you're correct. Is it allowed? Probably not, okay? And here's why. The therapist is a practicing clinician who submits claims electronically to insurance carriers through that private practice, and therefore they meet the definition of a covered entity. Okay. So, in addition, this therapist is using patient information obtained from their electronic system that's used in the course of their work, albeit it's with patient consent to work with the general contractor. It's still that information is still protected by HIPAA law. So if the general contractor is working with that covered entity therapist and they're using the protected health information supplied by that therapist to do the work for the client, this likely meets the definition of a business associate to the therapist. Now the GC would have to follow HIPAA, okay? But they could avoid engaging in HIPAA protected engagements by not accepting personal or protected health information from the therapist about the client. Think about going back to the minimum necessary. Do I need this information to build a ramp? Do I need it to install grab bars? Probably not. There are a host of other issues and concerns with this example, but as a therapist, you likely should be providing your patient with the general contractor's contact and letting them contact the GC directly. It's also likely a clinic policy violation to be using information out of their EMR and supplying it to anyone without the clinic being involved, because they have a responsibility to track that information. In scenario 6, you are a CAPS GC and one of your client's family members provides you with information related to their parents' multiple sclerosis diagnosis in the course of a conversation when they reached out to you to learn about your services. You didn't ask for this information, but it was disclosed to you in the course of a conversation. Is this a HIPAA violation? If you answered no, you would be correct. A person's family is not tied to HIPAA law. And while it might be private and personal, it's not illegal for you to receive that information from them. And in this last scenario, you're a GC and you're working with a durable medical equipment company in your area. And you plan to use this company to come and provide some equipment for a wheelchair ramp in your client's home. Okay. And you have no medical information on this client. You don't share any information on the client's health condition with the company, but rather you provide the need and the measurements, and then you hire them to supply the equipment on your behalf. Does HIPAA apply to the general contractor in this scenario? If you answered no, you would be correct. A general contractor doesn't meet the definition of a covered entity or a business associate and isn't using PHI to conduct their business with a medical equipment company. Now, there are DME companies who do meet the definitions of covered entities and business associates, but that doesn't necessarily impact you in the course of this scenario if you aren't using any PHI that they provide to conduct your business affairs. So hopefully after going through some of the scenarios, you can start to see the difference between following and being required to follow a federal law and what would be considered the topic of what we call privacy and confidentiality. Okay. So while it's not always cool to reveal sensitive or private information that you may know or learn or be exposed to in working with a client, it's not always illegal either. Okay. So there's a difference between being required by law and breaking a law and being permitted by a person to protect the use and disclosure of their health information. So if you're not required by the law, it's not illegal. And then stating that you follow the law or having clients sign acknowledgments that you do puts you as an individual or a business at a liability to follow it. If you are required to follow HIPAA by law, you have to follow each and every single rule and requirement. You can't pick and choose what HIPAA privacy and security rules you want to follow or what's easier to implement. Okay, so you can see that following the rules when you aren't required to do so can be a liability risk for your business. Privacy and confidentiality may have state law implications, so it's important to understand these topics as well. So you understand that I am dealing with sensitive information. It doesn't fall under the premise of what's protected by the law, but I might, from a state perspective, in the state I'm incorporated in work, have state laws that protect this information. So if you're not required to follow HIPAA, It may still be best practice to ask the client for their permission for you to receive private details about their health status or their care, and let them know how you plan to keep that information confidential if you think that it's necessary. And your attorney may even suggest you have this in written form and have them sign it. And really, you need to heavily consider if you even need this level of detail to do your job. Okay. The signed statement that your attorney may ask you to put in place is what's known as a privacy and confidentiality statement. Okay. And it should be developed by your attorney, not something you create on your own. And that's because there are state law implications that could be possible. And keeping things private and confidential, whether that's conversational or whether that's in the form of some sort of electronic data, is not HIPAA necessarily. Okay. You have to meet the definition of a provider or an entity or associate that's required by law to follow it. So if you have a waiver and a release of information that will help protect your business as long as you adhere to what you say you're going to do, that might not be a bad thing to do. And it probably also would give some comfort to the client that they can trust you with intimate details about their personal life and health. If the client is unable to sign it themselves, maybe they have some sort of physical or mental incapacitation, your attorney may want you to have their power of attorney or their medical power of attorney or their legal representative sign some sort of waiver and release of information. But again, navigating federal and state laws and the difference between the two and the differences and nuances for your business is why it's highly suggested to work with an expert. And so on these last two slides, I'm just going to provide some recommendations for therapists and GCs as it relates to HIPAA. And again, this is not legal advice. It's just scenarios for you to run by your own attorney or compliance officer so you can come up with the proper business solution for your unique business needs. Okay. So as an OT, you can work with general contractors in the capacity of a consultant and not necessarily be considered a covered entity, which means if it doesn't, HIPAA doesn't apply to you. Okay. So there are ways to structure this, and there are certain actions to take and actions to avoid. And so doing your homework on how to present yourself to clients and how it may or not apply to your license and your state practice act, et cetera, are all items I highly advise you to explore. Okay. So assuming you don't fit the definition of a covered entity and you aren't practicing in the clinical sense and using information from your practice to consult with a general contractor, you could work with your business attorney to draft a waiver and release of information for which your clients sign, and really essentially promises your confidentiality with any health information that they share with you. And that information should really be on a need to know basis, only for the strict purposes of doing your consulting work with the CAPS general contractor. Okay. So keep in mind, a client can share whatever health information they want with you as a private citizen or a private consultant, but it doesn't necessarily constitute HIPAA. Okay. So it's ensuring that what you are asking for and what you are doing in the course of your business from a job duty perspective is always best to run through an attorney. And if you're a practicing clinician who uses health information of clients or patients as approved, and if you're functioning in the capacity of a healthcare worker who is using or accessing or disclosing a patient's PHI for use in the work you are doing with a CAPS GC, you likely implicate HIPAA and likely will implicate your partner in it as well, the GC. So if you need and should follow HIPAA, or you're unsure if you should, there's a couple of recommendations. First, always speak with your employer to ensure you are following the proper use and disclosure policies and procedures if you are using information from your job to work with a GC. And this is a great place to start, as your employer also has responsibilities in this process. Okay. And since it's so crucial to ensure full compliance with the law, spend the money up front and get an attorney. It will save you a lot of heartburn in dollars in the long run if you would make a mistake, or you don't set yourself up properly, or you market yourself inappropriately. Okay. And then ensure you get the proper business associate agreements in place, and that you have frank discussions with anyone you will work with in this capacity, as general contractors don't normally follow HIPAA guidelines. Okay. You want to make sure you don't put yourself or them at risk. And in those agreements, your business partners will have to attest to being fully compliant with all the federal HIPAA privacy and security regulations. And keep in mind, if you subject partners to HIPAA unnecessarily or even necessarily, it may jeopardize your reputation and it may limit your ability to work with certain contractors. For GCs, generally you are not required to follow HIPAA, and therefore to keep your personal and business liability to a minimum, it's best that you consult with an attorney on the proper setup and if you need a waiver and release of information with your clients and consultants. So highly consider as a GC working with other consultants who will not subject you to following those federal privacy and security laws if you are not set up for it. Also, never sign a HIPAA business associate agreement that ties you to following all the laws without ensuring that your attorney has looked at it. And in all honesty, you shouldn't really need protected health information in most instances to do your job anyway. Okay. The other thing that you have to consider is that there are state laws that also come into play. So do yourself the favor, work with legal in the beginning to set yourself up properly. And if you're already in business and any of this presentation makes you question what you're currently doing, seek out legal counsel. If you as a GC do consult with a practicing occupational therapist who is required by federal law to follow HIPAA, and as a result of their business dealings with you, shares that information so that you can do work on behalf of their client using PHI, you should definitely work with a healthcare attorney to set up a proper HIPAA compliance program. Okay, you want to create and enforce all the program requirements with your staff and in your offices. You want to draft business associate agreements and use them with your covered entity consultants. And then you want to work with a third-party contractor to regularly audit your compliance with the law. Okay, and so the same applies here. It's worth it to work with an attorney and assure that this is set up properly at the beginning and to learn what to sign, not to sign, what to use, what not to use, what to disclose, what not to disclose, and how you market it. So I have listed my contact information here if you need to reach out to me with any further questions. But for now, I guess Steve will open the floor and address any additional questions at this time.
Yeah, that was fantastic, Meredith. Anyone that has a question for Meredith, please.
Meredith, it's Rebecca. Thank you so much.
Absolutely. Hopefully it wasn't confusing, even though it's a very great topic. It's very, very important that you understand where the law applies. And I think that that's the key takeaway here is that most of you in the context of what you probably are doing do not fall under HIPAA.
Meredith, this is Hugh Bailey. I really appreciate the information, the wealth of knowledge that you presented. Very interesting.
You're welcome. If anybody thinks of any questions later too.
I have a question for the
Sure.
for the group. So you are meeting with the client and they open up and tell you about their situation, maybe some treatment or forecasts for their recovery to the contractor. The contractor's present, maybe a designer and so forth. So how does that impact laws that might apply or don't apply?
So two things. One, myself as a private citizen, I'm able to disclose whatever I want about myself to anyone that I want at any time. It does not make it protected by federal law. The only time that information is protected by federal law is once it sits in the confines of meeting the definition of a covered entity or business associate.
So I would be free if we were having a conversation in your home or in your hospital room or wherever or over the phone, and then I brought my team together and shared that information. Is that still okay?
So two things. One, you're not violating a federal law. So that's the most important point. The second thing is that it would not hurt you as a general contractor to just ensure there are no state privacy or confidentiality laws that you needed to be following.
Okay.
That I couldn't answer.
Right.
There may be some privacy and confidentiality or some sort of waiver release form that your attorney would recommend, but you are not breaking a federal HIPAA law.
Okay. And I think it was great, the points you made about, don't go there if you don't need to. I mean, that's my bottom line take on it, which I think is fantastic.
I can't tell you how much time, effort, and money it takes to oversee a HIPAA compliance program. And I mean, if you think about all of us here on the phone, we're all going to be patients. If we haven't already, we'll be a patient for somebody at some point, right? So the fact that the government goes to this length to try to protect our information is great for us on that side. On the healthcare provider side, it is very complicated, expensive, and comes with a high price tag if you're not following those laws. I can tell you that as a HIPAA administrator for a large national company, we've had to report incidences that, you know, we honestly could have done very little to prevent. We were hacked several times, and our data was held at ransom for millions of dollars. And we paid almost as much in forensic analysis and attorney fees and all the reporting and things that we had to do in relation to the law that we have to follow. And it was almost the same as paying the ransom. So, you know, it is a lot of liability. So it's very important to understand if it applies to you or if it doesn't.
Okay, fantastic. Other questions, please? We have a
Yeah,
couple.
question. Yeah,
Yeah.
question. What if you're working with an OT or a PT, and they are giving you information about the patient, such as someone is unable to climb the stairs or they have dementia, and they provide that information? The concern I have is, how do I verify that they're working independent of their employer? How do you handle that?
I think that should be structured very clearly and plainly in your contract with them as a consultant. So it should really outline how the capacity and how they're working with you. You know, if they're working with you as an independent consultant, private pay, it has nothing to do with their actual license or in the context of working within a covered entity clinic. But I would definitely have your attorney review those contracts to make sure that they don't unnecessarily tie you to have to follow some sort of law just because it wasn't mentioned in here and you haven't asked the right questions.
Yeah, let me tag
Thank
on
you.
to that, if I can anticipate. As a therapist in a clinical setting, you met someone, and now you are in a private setting with that same individual. What about using information that you obtained previously? Or
Well, I
not?
think that is a very fine line. And if I, as the licensed occupational therapist, would keep that completely and totally separate. If I learn information about you in the context of working within my clinic in my job, I'm going to ask you as the patient to contact the GC directly, and you guys just work together. If I meet you outside of the context of my clinic and I'm working as a private consultant with that GC, then I can work on behalf of the client with the GC. I would draw a very distinct line between what I'm doing.
Good answer. Thank you. Okay. Anyone else? Well, Meredith has demonstrated that she is open to interacting with us, so feel free to reach out to her. We'd really appreciate this. We'll have you back. This was great.
Absolutely. Happy holidays to everybody.
Everyone, yes, thanks so much.
Thank you,
Thank you,
Meredith.
Meredith.
Appreciate it.
No
Great
problem.
presentation.
Bye-bye.
Thank you.